Good morning. Good morning. I mean, grand rising. I keep forgetting I'm changing that word in my vocabulary. Grand rising, good people. Grand rising. Once you know something, you should be doing better. And I learned the meaning of that whole phrase of good morning. It was a slavery um, condition. It was the night before when the slave masters used to beat the slaves, and they would ask them, "Hey, did you have a good morning last night?" So I changed from that vocabulary. So I have to change to grand rising, grand rising. So that's, you know better, you do better. Anyway, good morning. Gosh, I said it. Grand rising. It's going to take some time, good people. Well, wonderful folks, hello, hello. Listen, those who are ready to sit down and have a moment of education, this is one of those mornings, guys. This is one of those mornings. I feel like being the teacher today, right? So get your notebook ready, get your pads, get all your learning equipment ready, because today we're going to go through this whole YSL stuff. We're going to do some breakdowns, and it's not going to be the normal breakdown. I'm going to bring some stuff to you guys. Memory, we're going to go over the motion that was just recently filed, and we're going to go back, go way back, and we're going to do some breakdowns of what individuals were charged with. Who are the individuals that are severed? Who is the individual that got a bond? Why did that individual get a bond? Those type of things. Just a refresher for those who are just learning about this case, those who know nothing about this case. I'm going to be that make-believe teacher today. You guys ready? You guys ready? And what I'm going to do first is I'm going to get my reader, Liz. Liz, if you're in the chat, I just saw you in the back. Could you come back into the backstage so I can pull you up so you can read this for me? All right. So I'm going to let Liz read. I have 3 motions that she's going to read for you guys. First motion is going to be with love, the motion that Attorney Steele put in to have Love and Hilton to be removed from this case. Then the other motion is going to be the motion in regard to I think what it's called. Hold on a second. Let me just get what it's called. Hold on. Let's see. It's called, I have to get the proper word. It's called a motion to invalidate and strike all proceedings that occurred in the above reference case. And then the last one is going to be motion to challenge factual finding, not result of the Honorable Judge Cross. So those are the 3 motions that Liz is going to read. You guys, please be nice in the chat. I don't want to hear any complaints about anybody's reading ability. If you have a problem with what is being done, you can exit stage left and have a wonderful day. But this is a day that we're going to sit and we're going to analyze and talk about, give you the breakdown of this case, because a lot of people don't know. They don't know who the severed defendants are, and they don't know what the charges of individual. They don't know a lot of things. So what we're going to do today is just do the breakdown. Okay, do the breakdown, answer some questions that you guys may have. This is going to be a real slow pace, so patience. If you don't have patience, this may not be the live for you. Okay, all right, here we go. Now here's my reader, Liz. Liz has been so gracious to volunteer to come up here and read. And if you guys have a problem with her reading, then volunteer and do some reading yourself, okay? All right, here's Liz. Hey Liz, good morning. Thank you so much for being here, being my willing participant.
Good morning. Can you hear me? Hi, chat.
Good morning. But Liz, we got to make sure your mic work well too, because sometimes they're not able to hear you clearly. Okay?
Yeah, we're doing a sound check. I have it on automatically adjust the volume, so
Okay.
somebody
So
let me know how it is. I'm
you
on my
sound
AirPods.
you sound pretty good right now. But if something goes wrong, I'll let you know. So the first reading you're gonna do is for the motion to disqualify Love and Hilton. Okay.
Okay, I have it up. Are you gonna put it on the screen too?
Yes, I am. Just patience, my dear. Patience. All right, here we go. All right, there we go. Now, here come Liz, y'all. Go ahead.
If I start reading too fast, somebody just hit the chat. Sylvia will say.
Just take your time. We got a lot of time this morning. Just take your time, okay?
Okay. Motion to disqualify lawyers Love and Hilton. Comes now Mr. Jeffrey Williams by and through undersigned counsel and hereby files this motion to disqualify lawyers Love and Hilton in the above referenced case. In support of this motion, Mr. Williams shows as follows. Number one, Mr. Williams is innocent of all crimes in the above referenced indictment. Number two, as previously asserted, lawyer Love and Hilton have made themselves critical witnesses in this case, including but not limited to when lawyer Love engaged in text messages with witness Archelian Bennett, and lawyer Love, lawyer Hilton, and Judge Glanville communicated with sworn witness Woody at a critical stage of Mr. Williams' trial during the now infamous June 10th wholly improper ex parte in chambers meeting. Number three, undersigned counsel has the duty to examine Mr. Copeland, lawyer Love, lawyer Hilton, and Judge Glanville on all facets of the secret strategy session pursuant to the Confrontation Clause, right to present a defense, 6th and 14th Amendments, right to effective assistance of counsel, due process, right to a fair trial, as well as fair tribunal on behalf of Mr. Williams under both Georgia Constitution and the United States Constitution. This will mandate that Woody be cross-examined before the jury about his meetings
Could
and
you please
conversation.
hold on? Could you please read his name and not Woody? Thank you.
Yeah, I will. This essential questioning injects the veracity and credibility of lawyers Love and Hilton and Judge Glanville. Undersigned counsel will also examine lawyer Love, lawyer Hilton, and or Judge Glanville as to why they knowingly made false and misleading assertions to Mr. Copeland about the alleged disloyalty of Mr. Copeland's lawyer and provided legally incorrect information to Mr. Copeland in order to persuade Mr. Copeland to testify against Mr. Williams. Number four, based upon their own deliberate and intentional concealed misconduct, Judge Glanville's, lawyer Hilton's, and lawyer Love's credibility and acts are now at the center in Mr. Williams' trial. These lawyers must be removed and disqualified from further participation in the case, save as witnesses. See Georgia Rules of Professional Conduct 3.7. Number five, during the jury charge, it is expected that this honorable court will be asked to instruct the jury as to suggested pattern jury instruction 1.70.10 as follows. The court has no interest in this case. By no ruling or comment that the court has made during the progress of this trial has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Undersigned counsel requires this above testimony from lawyers Love and Hilton and Judge Glanville in order to have the deliberating jury consider whether Judge Glanville was in fact biased for the prosecution and that the jury instruction is not applicable prior to July 15, 2024, the day Mr. Williams' motion to recuse Judge Glanville was granted. Wherefore, Mr. Williams respectfully requests a hearing on this motion, and at the conclusion of same, asks this honorable court to grant the above requested relief. This 18th day of July, 2024, respectfully submitted and signed by Brian Steele and Keith Adams.
Thank you so much, Liz, on that one. Before you start on the next one, guys, that motion is self-explanatory. Basically, Mr. Steele is asking the judge to rule on Hilton and Love being removed from this case. He gave the different reasoning. One is when Love placed herself as a witness when she was examining Miss Bennett. There was some testimony that was basically given during the time of the examination, and it was improper, and there was some things that was done during that time. And also the ex parte meeting with both Love and Hilton with Mr. Kenneth Copeland. Okay, so that is the meat and potatoes of this particular motion, is to request that those two be removed from the trial. Okay, so Liz is going next. She is going to read the invalid and strike a procedure occurring. That is the one dated 7/19. You have that one? Liz? Liz? Are you there?
Hold on, yeah. Somebody was at the door. Hold on 1 second. It's Blaze's lights. I just had to sign. Hold on.
All right, guys. Just anybody have any question until Liz comes back? Anyone have any questions?
Okay, ready?
All right, Liz is back, guys, and let me go ahead and put it up so she can begin reading. All right, here we go. You got it? This is the motion to invalidate and strike all proceeding that occurred. You got it?
I have it, yeah.
Okay.
Motion to invalidate and strike all proceedings that occurred in the above referenced case on and after the initial motion to recuse Judge Glanville was filed on June 12th. Comes now, Miss. Oh.
Your phone kind of sound a little bit not excellent. Anybody move up a little closer? Yeah, it's better. Go ahead.
Okay. Comes now Mr. Jeffrey Williams, by and through undersigned counsel, and hereby files this motion to invalidate and strike all proceedings that occurred in the above referenced case on and after the initial motion to recuse Judge Glanville was filed on June 12th. In support of this motion, Mr. Williams shows as follows. Number one, Mr. Williams is innocent of all crimes in the above referenced indictment. Number two, on the afternoon of Wednesday, June 12th, 2024, the Honorable Douglas Weinstein, counsel for Mr. Diamante Kendrick, filed the initial motion to recuse the previous trial judge. Mr. Williams filed a separate timely motion to recuse on Monday, June 17th, 2024. Both motions to recuse were granted on Monday, July 15th, 2024. Number three, if a party files a motion to recuse a trial judge and the motion is denied, but it is later determined that the judge should have been disqualified to act in the case, all proceedings after the filing of the motion to recuse are invalid and of no effect. See Probst v. Morgan. Number four, in the case at bar, Judge Glanville denied the Honorable Attorney Weinstein's timely filed motion to recuse on June 12, 2024. as well as Mr. Williams' timely filed motion to recuse on June 17, 2024. Since these motions to recuse had merit and were granted, all proceedings that occurred after the filing of Attorney Weinstein's motion to recuse from June 12th through July 1st, 2024, when Judge Glanville stepped away from the case, which include the number 1, testimony of witness Copeland, 2, exhibits admitted and displayed to the petite jury, 3, Judge Glanville's rulings on any and all evidentiary issues, and 4, the like must be erased forever in toto from the jury's mind in any rulings that occurred in front of and outside of the presence of the jury are invalid. Wherefore, Mr. Williams respectfully requests a hearing in the motion, and at the conclusion of same, asks this honorable court to grant the above requested relief and instruct the petite jury accordingly, including but not limited to removing all juror notes from the relevant time period and erasing from the jurors' minds the invalidated testimony and rulings and any other matters that occurred during this relevant time frame. This 19th day of July, respectfully submitted, Brian Steele.
All right.
Thank you, Adams.
Thank you so much. Thank you, Liz, for that reading, guys. And this now this one as well is self-explanatory. Basically, Steele is asking that the judge erased everything that happened since the ex parte meeting. Well, not the ex parte, but since the June 12th motion that Mr. Weinstein submitted. All testimony from that point with Mr. Kenneth Copeland and any kind of exhibit or the evidence that they provided during that testimony that the jurors were able to hear and listen to would have to be wiped out of the mind of the juror, not be part of the proceeding. And
Sylvia, I can't hear you.
y'all, you guys can hear me, right? She's gonna have to fix her phone. She might have got a phone call. Can you guys hear me? Give me a thumbs up if you guys can hear me. Okay. Liz, you're gonna have to go out and come back in. You might have got a phone call and disturbed your sound. Let me kick her off. Hold on, let me kick her off so she can come back in because she can't hear me. All right, she's gonna have to bring herself back in. That happens when they get a phone call. If somebody calls them when they're on StreamYard, it makes the sound goes down. Okay. She's gonna have to come back in. But anyway, everything that happened after the motion that Mr. Weinstein put in to recuse Judge Glanville, all testimonies, all evidence that was produced, of, the videos they watch and all that has to be removed. All of it. Okay. So Mr. Steele has been putting in the work, haven't he? Hold on. Liz, you must have got a phone call, right?
No, I'm on my iPad. I couldn't hear you. I could see a picture and it moves. See how when I'm talking, that ring around me moves? I could see it, but I couldn't hear you. Then it kicked me out. I had to come back.
I know I booted you off because you would have to come back in for your sound to come back. So I did boot you off. I figured you'll come back.
I'm back.
Okay. So now we're going to read the last one, the last motion that Mr. Steele put in, which is the motion to challenge a factual finding, not result. Okay. So Liz is going to read that one. That's the final one. This one is going to be a little long, guys. No, it's not going to be long. I forgot. A lot of it's exhibit. So Liz, you ready?
I'm ready. I got it up.
All right, y'all. Let me put mine up. Hold on a second before you start. All right, go ahead, Liz.
Motion to challenge factual findings, not result of the Honorable Judge Krause's order dated July 15th, 2024. Granting the motions to recuse Judge Glanville. Comes now Mr. Jeffrey Williams, by and through undersigned counsel, and hereby files this motion to challenge factual findings, not result of the Honorable Judge Krause's order, dated July 15, 2024, granting motions to recuse Judge Glanville in the above referenced case. In support of this motion, Mr. Williams shows as follows. Number 1, Mr. Williams is innocent of all crimes in the above referenced indictment. Number 2, the Honorable Judge Krause made 2 findings that are respectfully erroneous in her order, granting the recusal of Judge Glanville, dated July 15, 2024. Mr. Williams is not challenging the result of said order, but rather the following. Number 1, Judge Krause wrote, quote, divorced from its hyperbole, Mr. Williams' motion and supplement also seek to recuse Judge Glanville because of his involvement in the ex parte meeting, which Mr. Williams also alleges was improper and coercive. There is nothing hyperbolic in Mr. Williams' motion to recuse an affidavit, and Mr. Williams stands by all law and facts therein. Number 2, that it is worth noting that the Honorable Judge Krause agrees generally with Judge Glanville's assessment of the propriety and of the ex parte meeting. While the meeting could have and perhaps should have taken place in open court, nothing about the fact of the meeting or the substance discussed was inherently improper. This finding is wholly against the law. At this improper ex parte hearing, Mr. Williams and his counsel had a right to be present for several reasons, including but not limited to, 1, the fact that Mr. Copeland provided statements not only bearing on the substance of his testimony, but also on his credibility. Number 2, there was enormous amounts of Brady evidence shared at this improper ex parte meeting that lawyers Love and Hilton and Judge Glanville all attempted to keep secret from undersigned counsel. And number 3, there was no lawful reason for this ex parte get-together. Number 3, there are more reasons that these findings by the Honorable Judge Krause are completely erroneous, but same do not affect the outcome of the correct ruling recusing the previous trial judge. Wherefore, Mr. Williams respectfully requests that this motion be spread upon the minutes of the court, and if needed, Mr. Williams stands ready for a hearing on same. This 19th day of July 2024, respectfully submitted, Brian Steele and Keith Adams. That was probably the shortest one. So, yeah.
Yeah, it was. It's just the extra stuff behind it. All right, my darling people. Thank you, Liz, so much. Liz, I appreciate you.
You're welcome.
You are awesome, and you are just so gracious for helping the sister out. You know, since they say I
don't
can't
mind.
read.
I like it.
But they're
Even
about
when
to
they're talking, I like it.
But they're about to suffer because I'm about to read some stuff to them. So, oh well.
Oh well, they're gonna like it anyway. All right, I'm gonna mute me.
All right, thank you, Liz. I appreciate you again. So, guys, here's what we're gonna do. We just read the motions that were submitted by Mr. Steele, right? The other day, Liz read the motion that Mr. Matthews submitted for motion for his defendant, Mr. Huey, for bond, right? And you know, a lot of the other defendants, the other 5 most likely will request a bond, right? So previously, there were, prior to the when the case first started, you guys know, Kayla gave us an understanding that they were indicted before they actually went to jail, right? By the time they were arrested, they were already indicted. And that did not give them a chance to do first appearance for bond, you know, where the magistrate judge have a hearing for them to receive a bond. So they never had a chance to go through that process. But during their incarceration, each defendant went before Judge Glanville after the indictment to request bond. But because there was an indictment in place, there was strong cause for them not to get a bond. And one of the main things that they had on every single one was the Rico. All 28 defendants had a Rico on their indictment, right? And that Rico basically helped to solidify the reason that they should not be allowed to enter back into society, because they felt that they were a threat to society and they were a danger to, and they believed that the community was not safe for all of them to be out. So every single one was denied a bond. Okay? Going forward, as the trial began and pretrial motions were submitted and back and forth, around June 2022, not June, I'm sorry, December 2022, there were plea deals given out to a number of individuals. There was a total of 8 individuals that received plea deals, and they were set back into society, right? And those individuals was Walter Murphy, also known as DK, Martinez Arnold, Mr. Greer, Sergio Kitchen, y'all know him as Gunner, Mr. Steven, you guys, he was one of them on a witness stand, Tick, he was called Tick. Mr. Walter Murphy, you guys know him as DK. Antonio Sledge, Antonio Sumlin. All 8 individuals received plea deal, and they were set back into society, right? And as the trial continued, 2 other individuals were given an out, right? Mr. Beebe joined the plea deal. Mr. Beebe received a plea deal because at the time his attorney had some situation going on, and he could not stay on a case, but they were able to get him a plea deal. So he was the 9th person to receive a plea deal. And one individual who is no longer part of the case because his case was dismissed, Mr. Darcy. Mr. Darcy's case was dismissed. So out of the 28 individual, these 10 individual case has been handled, taken care of. They're not considered to have to do anything with this. So then you have left over 18 individuals. Out of the 18 individuals, they are working on 6 individuals right now, the ones that we are seeing with this whole crazy case, right? And you guys know those individuals' name, right? You have Mr. Nichols, you have Mr. Stilwell / Jackson, you have Mr. Ryan, you have Mr. William, you have Mr. Kendrick, and you have Mr. Huey, which is 6 individuals. Then you have 12 individuals that was severed, right? 12 individuals out of the, what's the number? My math is not mathing right now, but you have 12 individuals who's been severed. And I'm going to give you the 12 individuals' name, okay? The 12 individuals, I have my list here. 12 individuals that have been severed is number 1, Mr. Adams. Those are writing, please write your notes so you guys will not get confused. Mr. Adams, Khalif Adams, Mr. DeMonte Blaylock, You have Jarvis Bradford, Christian Eppinger. It's number 4. Number 5, you have Javon Fleetwood. Number 6, you have Miles Farley. Number 7, you have Trancravius Mender. Number 8, you have Demise Mulligan. No advertisement for no. Yeah, you notice y'all supposed to ask me permission before y'all start doing this. Requesting advertisement for lives and channel. That's disrespectful now. Come on now. Don't do that. Supposed to ask permission before you do all that. Number 9, Mr. Jaden Myrick. Number 10, we have Mr. Jimmy Winfrey. Number 11, you have Justin Cobb. And the last one, number 12, Mr. DeMonken Garlington. So that's the 12 individuals that has been severed. Okay. Now, let's go talk about this bond situation. The only individual since this trial has started has received a bond was Mr. Miles Farley. Okay. Mr. Miles Farley is the only individual that is out on bond. And what I'm getting ready to do now is show you guys his bond hearing offer and his strict special conditions. Okay. His strict special condition. What we're going to do also is we're going to go ahead and read what motion that his attorney submitted for bond requests. Okay. The motion that he submitted for the bond request I have right here, and we're going to go ahead and okay, here we go. This is his bond request from his attorney. You guys see that? And his attorney asked for this is, I think, his second bond request. Liz, you want to read this one?
Yeah, I'll read it. Who's this? I was texting. Sorry. Motion.
Okay.
Oh, it's just this page. Motion, first page.
No. Did you want I can read it if because I can go ahead on.
Yeah,
I just wanted.
I was reading it off the screen anyways, but yeah, go ahead.
Okay.
I mean,
This motion was submitted in camera inspection of discovery, right? Meaning they did it behind the scene. And here's the motion that they request. Okay. He says at the first bond hearing, the state made several proffers about the unreleased discovery that were not accurate. So they're saying the reason why they should let him out is because of discovery information that was not accurate. And this should be a reason why they allow him to get this bond. Okay. All right. So he says attorney pointed this out at a subsequent bond hearing after the release of some discovery and asked the court to view certain parts of discovery in order to assess the nature of the charges against Mr. Miles Farley. Number 4, because attorney has not included this request in his motion, the court declined to view the evidence and instead allow attorney to proceed and to possibly do the request in camera inspection of evidence at a later date, which has not yet taken place. Number 5, at the same second bond hearing, after attorney proffered the true nature of the inaccurate proffer made by the state at the prior bond hearing. So is he saying they lied? Instead of addressing this, the state made a new misstatement concerning discovery that supposedly existed but had not been provided to attorney. That Mr. Miles Farley was recorded on the jail phones attempting to conceal evidence, but that these attempts had failed, and that the state had seized a phone and a gun of defendants that was supposedly incriminating. Number 6, this simply not true. So the state lied, right? State lied. Number 7, attorney subsequently filed a motion requesting to physically inspect the supposed phone and gun. And in open record, the state actors told the court that attorney could not come and inspect the gun and phone at an agreed upon time. Number 8, that same day within the courthouse, while hearings for the co-defendants were still taking place, the state's actor told, you know who that is, right? Told attorney that in fact the state was mistaken and that they had not seized any phone or gun related to Mr. Farley. So they lied, y'all. Mr. Miles Farley. So they lied. Number 9, when the jail calls in question supposedly about this gun and phone were released as part of discovery, and yet again these calls apparently do not suggest at all what the state proffered they would. Number 10, in order to adequately apply the alea factor in a genuine way to Mr. Miles Farley, for the first time, the court would benefit from an in-camera inspection of the music video, which the state made misstatement, again, a lie, about the surveillance video, which the state made misstatement about, and the jail calls, which the state made misstatement about. So they lied about the surveillance video. They lied about the gun. They lied about the phone call, the jail call, right? Number 11, on this day, everything incriminating the state has proffered about Mr. Miles Farley has turned out to be just demonstrably false. In other words, a big lie. You know, demonstrably is big, right? Big lie. In this uncertain terms and without any ambiguity. Number 12, he did not greet anyone within the BP on the surveillance footage. 13, he did not create or even recite any lyrics in any videos, nor does he demonstrate any unlawful activity in any music videos. Number 14, he does not say anything incriminating on any jail calls and does not attempt to tamper or conceal evidence. And the state does not have the phone and gun that it proffered it had, and then made an appointment for attorney's inspection of these items in open court, knowing it did not have the items. Bond factor. Number 1, defendant is a resident of Fulton County with deep community ties. 2, defendant has financial support while out on bond. 3, defendant has never failed to appear at court and has never been arrested. Number 4, defendant is not a risk or danger to the community. Number 5, there is no risk of defendant tampering with proposed evidence. Number 6, if defendant is released on bond, he shows that A, he will not present a danger to society. B, He will not intimidate any witnesses. C. He will not unlawfully flee the jurisdiction of this court. D. He will not interfere with the administration of justice. E. He will not appear without fail to any future court appearance from time to time and from term to term as required by the court. Number 7, if released on bond, defendant shows that he will gratefully and humbly accept whatever condition of bond are required by this court. The contemplated condition of bond may include, but not limited to, all of the following. A. Defendant be subject to a curfew. B. The defendant continue his employment and maintain his employment throughout the disposition of this case. C. That the defendant avoid all contact with person of ill repute and co-defendants in the new charges and place in indecent character, places of indecent character. Now, D. That defendant not poses any weapon of any kind. E. That defendant not poses alcohol or illegal drugs, nor be in presence of any person doing the same. F. That the defendant be required to report to a probation officer on or other pretrial officers for weekly progress check to ensure compliance with these conditions. G. That he be required to abide by such other condition as deemed just and proper by this court. 8. In support of this motion, defendant shows he is entitled to a reasonable bond under applicable law. Remaining in custody places the defendant in a precarious position as it prohibits him from earning income, attending to important family needs, and assisting his counsel with preparing his case. To be sure, in our society, liberty is the norm, and detention prior to trial is the carefully limited exception. United States versus Salinino. For this reason, the issue of bond is an important one and should be considered by the court where the interest of justice allowed for it. The statutory criteria for denying a bond in this court requires a finding that the defendant poses a significant risk associated with pretrial release. The mere possibility of risk does not provide a sufficient factual basis to withhold bond entirely, particularly since the foremost condition when fixing bail is the probability that the accused, if freed, will appear in court. Poland versus Dorsey. Defendant also requests for Number 9, defendant also requests for a reasonable reduction in bond, since the primary purpose of the bond is to ensure the defendant's presence at trial. A bond which is higher than the amount calculated to effect such an end is excessive. Stack versus Boyle. Accordingly, reasonableness of bond is determined in terms of the particular defendant. Bennett versus United States. To that end, while considering whether the amount is sufficient to cause the defendant to be present for trial, it is proper for this court to consider the accused's ability to pay, the seriousness of the offense, and the accused's character and reputation. Howell versus State. Wherefore, defendant pray that this honorable court will: A. Schedule a hearing for this motion as soon as practically possible and to place the district attorney's office on notice of the same. B. Consider the evidence to be presented at the hearing together with the circumstances surrounding the case as a whole and find the defendant is entitled to a signature bond. C. In the alternative to a signature bond, reduce the bond from its current amount. D. Order that the defendant comply with all conditions deemed by this court and to be reasonably necessary to protect the community and ensure appearance in court. E, make specific findings of fact on the record if bond is denied, so as to facilitate an appellate review. And F, order all other relief as deemed just and proper, respectively submitted this day, November 29th, 2022. Anastasios Manis. All right, that is his request for bond for Mr. Farley. Okay, now, okay, he was granted the bond. He wasn't granted it in November when he originally asked for it. He was denied. But when they turn around the following year in April 2023, when the attorney was arrested, remember, he's the attorney that was arrested when they said he had drugs. Remember that? Well, at that point, they decided to give the bond. And here was the bond condition. Hold on, guys. Let me get the bond condition for you guys. Hold on. This was on the 21st of April 2023. And I have it right here. I just want to make sure I don't have any addresses on here, because I can't show addresses. Okay, let me make sure there's no address being shown here. Oh, there is an address. No, that's just where he cannot go by. Okay. Okay, so I cannot show his address. So I'm gonna show certain parts, and then I'm gonna remove it and then come back to you guys, okay? Because there is an address on here, and I cannot show the man's address. Okay, hold on. Let me show you this part of it. This is the bond that he was given. All right, here we go. All right, here we go, good people. Okay, this is the bond he was given, and it was done on April 21st, 2023. He was given a $625,000 cash property or surety bond. Okay, but let me show you what the charges he had, so you guys will know why they felt he was dangerous. Okay, he has conspiracy to violate racketeering, influence, corruption, which is the Rico, right? The Rico Act. He has murder, y'all. Y'all see? Murder, right? He has participating in a gang streak activity. Gang activity again. Possession of a firearm during the commission of a felony. So you see those charges? And he was given a bond. Okay? So that's all I can show you now, because I don't want to make a mistake and show you the address and stuff like that where he's at. But he did have some condition on his bond. And let me just tell you some of those conditions. Okay, hold on. Let me just tell you. Can't show you all of it, but I can tell you. Hold on. All right. Because I don't want to make an error of showing the address where he's at. Okay, he cannot come within 20 yards of the victims, right? Victim's family, and he can't email them, can't phone them on the phone, can't no third party contact or none of it. So he can't reach out to the victim, okay? And then victim's family and all that. He has to reside with his grandmother, right? He must surrender his passport. He must have a GPS monitor on him, paid by the Fulton County. He must pay. He must pay for the GPS tracking. He's only allowed a certain amount of radius to be outside of his home. He can go to work and things like that, but he cannot stay outside. He has a curfew. He may not be in contact with any co-defendant or anybody like that. Cannot email them, cannot talk to cannot talk to them, but he can talk through the counsel. Like he could talk to Steele, and Steele could refer the message to Jeffrey if he wanted to do something like that, right? He cannot use any social media. He must refrain from any communication, direct or through third party, of any family members of victims. Again, they put that in there. He must stay at least 1,000 feet from a certain location, Cleveland Avenue. He must stay away from Cleveland Avenue. He can't go to Water Street. He can't go Cleveland Avenue Park. He can't go anywhere. He can't tag. He can't wear any kind of advertisement of any YSL paraphernalia or anything like that. He cannot promote any gang signs or activity, wears, posting, tagging, advertisement, nothing having to do with the gang. He cannot do that. Okay. That's basically it. He has a curfew, and his curfew, he can't, okay, there's more stuff. I'm sorry. Defendant shall reside at the home and should not change his residence without the prior approval of the court. Defendant shall not have any contact or direct or indirect with third party, with the alleged witness, co-defendant, or victim in this case. Furthermore, defendant shall not come within 200 yards of the residence, place of employment, school, or place of worship of any victim, right? Wherever the place is located, defendant shall not possess any firearms or occupy a residence with a firearm. That means if he knows somebody has a gun in the house, he cannot stay there, okay? Defendant shall not have no contact with any alcohols. I mean, he can't drink. He can't have any kind of narcotic, any kind of drugs. Only thing he can have is prescribed medication from his doctor. Defendant shall be submitted to a random drug test. So he has to get random drug tests on a consistent basis. Defendant his curfew is from 10 p.m. He got to be in the house by 10 and cannot leave the house until after 6 a.m. So he has to stay between 10 and 6 a.m. Only time he can leave if there's a medical emergency, so he has to be rushed to the hospital or something like that. So that is the condition of his bond. Any question on that, guys? Any question on that? Any question? Okay, y'all want Jeffrey's charges. Okay, we can do that too. I have that. Here we go. I'm going to pull up the first indictment that Mr. Jeffrey originally had. He had 2 charges, and I'm going to explain everything to you guys. Hold on. Hold on. Just 1 second, guys. I was trying to get the original indictment before they change it over to the second one. Hold on. Just 1 second. Just a bit of love. A little bit. Hold on a second. Just a bit, a lot, a little bit. He has such a large paperwork, oh guys. I just got to go all the way to the bottom. He has over 600 and something filing. Just bear with me a second. Just a second. All right, let's go ahead and I'm going to do the indictment that they have right now. Okay. Let's go ahead on and pull up his Mr. Williams stuff. Just a second. See, I didn't expect you guys to ask me that question. I just like. Can y'all get the hit the like button? Hit the like button. It's free. If you guys want me to continue giving you guys this information, go ahead and hit the like button. That's the least you can do for me. Hit the like button, my good people.
Sylvia, you're going to act like you can't read, and you just read the longest motion we had today.
Oh, no, I can't. They say I can't read. That's what they said. I can't read.
I know.
I'm disagreeing with them. They say I can't read. That's what they said. I can't read. I can't read. I agree with them. I can't read. Half the time I don't want to read. That's huh?
I said, you sure read just now, though.
I can't read.
Watching it. Whoever said it, I hope they're watching.
Ma'am, I can't read. Okay?
Stop.
I'm going to agree with them. I can't read. I don't know how to read. Sure can't. They don't understand the difference between lazy.
Lazy and not loud enough.
Lazy. That's what I am. Lazy. I don't want to enunciate word. I don't feel like it because, once you get to a certain age, you don't care. I can't read. That's fine. I can't read. Okay, yeah. Huh?
I'm going to drop off, okay?
Okay. Guys, hold on a second. I'm trying to pull up I was trying to get the original, because he originally he was only charged with two counts, right? Let me just write the number. Hold on, y'all. I get it for y'all. Hold on. But I have the second indictment. I was looking for the first one so you guys could see what he was originally charged with. Hold on, let me just write the indictment down. It's 22 SC 182273. Just hold on a second. Okay, here we go. Because the original indictment, what Mr. Jeffrey Williams was charged with originally. Okay, originally, Mr. Williams was charged with this. Hold on a second, guys. Let me just bring this up to you guys. Hold on. Hold on, y'all. Y'all the one who asked me for this part. I was not even preparing to do this. Y'all asked for this. So y'all just hold up. Hold on. All right. So here we go. I'm going to open this up, and then I have the other one, the new one. This is the first indictment that they had for them. And Jeffrey was only charged with 2 counts, right? First count was, this is the first one, 22 SC 182273. This was the first indictment that was done on May 9th, 2022, right? And we're going to go down to Mr. Williams down here. And you guys can see he was originally charged right here with 2 counts, which was number 1, which is the Rico, and then 56. So we're going to go down to the first one, number 1. All right, hold on. We're going to go down to number 1. Okay, number 1. This is, everybody got this, number 1. The grand jury hit the number 1, right? And you see, this is the conspiracy to violate the Rico, right? And this is all the parts of that. So he has number 1 and number 56, right? So we're going to go all the way down to 56. 56. This is all part of 1. We're going to go all the way down to 56. 56 is his next. Okay, ready? We'll go all the way down to 56. We're going to go all the way down. This is still 1. This is still 1, y'all. Hold on. These are all the acts right here, but we got to go to the charge itself. These are the acts. It's over 100 and something acts. 198 or something like that. This is the one with the... Okay, let's go down. It's taking too long. Get down there. Okay, now here's a count. These counts 56, right? We had number 9, 10, 12, 16, 19, 22, 25, 27, 29. We got to go to 56. Come on, we got 37, 39, 40, 44, 48, 50. We got to go to 56. 56, we have 52. Now here's 56. This is what Mr. William was charged with. It says the grand jury aforesaid in the name and belief of citizen of Georgia do charge accused Jeffrey, aka Thug, aka Slime, with the offense of participating in a criminal street gang activity. So he's charged with the street gang, right? And it says here the activities of the gang. This is what the gang, the group of the gang supposedly did. Allegedly, the gang did this. So he's charged with the gang, but the activities of the gang is what they're saying that they're charging him because he's the leader, supposedly the leader, allegedly the leader. But the people in the gang did the following things of these things. So he's being accused of it as well. Okay. He didn't directly do it, but indirectly they're saying he's part of it because he's the leader of the pack, the wolf pack. So he had 2 charges at the time, right? He had the Rico and being part of a gang. That's what. So then later on, they went and made it more specific. He didn't, it's not personally to him. So now we're going to go into the current indictment, okay? And then I'm going to show you that right now. So if you go right here, the current indictment, which came a few months later. This indictment was done when August 5th, 2022. The first one was on May 9th when he was arrested. They had an indictment already done. So now this one is the second indictment where they added some more charges. All right, they wanted to be a little bit more specific for him. So if you go down here, we're going to do Jeffrey Williams. Let's see if it's up here. Okay. We're going to go to Jeffrey Williams. We have him here. Hold on, we got to go back up. Make it bigger so you guys could see. Hold on, making it bigger. Okay, Mr. Jeffrey Williams. Going to go back up. Go back up. Come on. Okay, Mr. Jeffrey. It's supposed to be Jeffrey. Oh, you're going by the last name. Williams. He's all the way at the bottom. W. Okay, you see him right here, Jeffrey Williams. They added more. You remember it was just 1 and 56? They added 57, 58, 59, 60, 61, 62. You see those? Those are the counts. So we're going to go down and see what 57, 58, 59, 60, 61, 62 is. So we're going to go all the way down like we did before. Come on, we're going to go all the way down. We're going to go all... Is there a way we're going to make this faster? Oh, there we go. I'm going to make it faster. I'm going to go all the way down. We're going to count. We got to go to 57, 58, 60, 61, 62. Okay, hold on. We got to go back up. Okay, let's go down. Okay, we got 51. We did 56 already. We already knew 56. 56 was that, right? Right, we got that one, all right. And then we got 57. They accusing him of that. That's to participate in this street gang again. Possession of marijuana and blah, 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 right? Then we got to do, this is Mr. Williams. See, he has his name here. They have him for 58. This is 58. Marijuana again, 59. All right. 60. Got his name again on this. 61. 62. Got his name in there again. And he's not on 63 good, but that's Kendrick, DeMonte Kendrick is on that one. So y'all see, right? And okay. So you guys got a chance to see that now, right? Are you happy now? You guys got it? So so that's what it is. Okay. So now what would you guys like me to discuss now? So now we got the breakdown on that one. From what they found in the mansion. Okay, that's what AJ said. Any other question, y'all? Any other question you guys want me to break down or? I know a couple of people was asking me, what was the stat? What was some of the stuff? Do you feel Whitaker will do with Steele motion. What do I feel? I'm not too sure. I'm not putting my feelings in any of this right now. I don't know. Not too sure. I know she seems fair. And the only thing I would be doing is speculating. He has to put in a motion for a bill. He hasn't put in a motion yet. QQQ says, Sylvia, do you think they had an ex parte with Courtney? But I don't know, Ashley. I don't know. I don't know. Guys, I don't want to speculate. I don't know. Don't want to speculate. AJ, telling you, jump on the panel. Pamela says, I just watched, hold on a second. She says, I just watched Big Jeff channel yesterday, and he said that was an illegal search and still beat that. So how can he be charged with what found in the house? There was a ruling made and certain things, there was a ruling made. There was certain things that the judge said they cannot bring into it. So they're gonna have to they haven't done a rewrite of the indictment, but there was some things that was thrown out. I remember back in November, and I do have the transcript for that hearing when they removed some things. And if you guys check my old videos, I read it and I talked about it. I do have the I have all the paperwork, guys, all of it. I have a lot of transcript. If we can do like a reenactment and have some people read the transcript if y'all would like us to do it. We could do that, certain things like the plea deals and things like that. Hey AJ.
Hey, what's going on?
No, I'm gonna beat your tail. Why you didn't send me a message and say, Sylvia, can I advertise my channel?
My apologies. That's why I stopped the conversation.
You know I would have did it, right? But you got to let me know before you do that kind of stuff, because then folks be thinking they could come up in here and do that kind of stuff. So you understand what I'm saying?
I feel you. That's why I halted the conversation.
Okay.
It was out of respect. But I don't know what the chat got going on, man. I was saying everything, in the chat in words. I asked you, what did you think with Steele's new motions? I feel like they're pretty cut and dry, especially given the way Whitaker says she's a stickler for the Constitution. I mean, these things, I don't see a rebuttal coming from a legit rebuttal coming from the state on any of the three motions to recuse themselves or to review the ex parte.
Well, let me tell you something. If they don't come strong with some good case laws, it's going to be a given.
Definitely.
If they don't come with some good, strong case law, because with the recusal, that part, I know for a fact that part definitely they're going to have to wipe out his testimony, because that's law. Because once that recusal was given, that in itself, you have to follow what the law says after the fact with that.
So Woody's testimony being stricken, that was the strength of the state's case, and now she's telling them to streamline the rest of the witnesses. I mean, I know we already said, who they got left. They had a bunch of cops that probably are not going to be on the list no more because the judge said, hey, ain't going to do no more repetitive. So it's in shambles for the state now.
Yeah.
It's in shambles. Because Steele has been sitting back just being quiet. Like, he's the only one out of YSL Avengers, I call them, who hasn't, taken an interview or done any, extracurricular activity. He's just been laser-eye focused on getting his client out.
Yep. Yep.
Along with everybody else. It's not just about Jeff. When he clears Jeff, everybody up under him gets clear.
Also what I found out, y'all, AJ, let me tell you. That's one of the reasons why I was late, y'all, because I said I was going to come on at 9 something, and then I was like, got it busy trying to dig through these paperwork and stuff, right?
Mm-hmm.
And I was looking at the severed co-defendants, right?
Right.
Do you believe if this case here gets them dismissed and shambled, the other one gets affected too? Did y'all know that?
It has to, because they're all part of the same thing. It's just that they're
Exactly.
it's not their turn up, because if none of them take a plea, which I don't think they're gonna even get an option to.
They didn't take the pleas. They didn't take
right. So when this case falls apart, that lets them know that, hey, I'm finna get out.
Yeah, because I saw the motion of recusal motion, the order, it's on their paperwork too, on their side also. I was like, oh, really? Oh my God. And every single one of their those defendants, all 12 of them, all 12 have that motion, that recusal motion, and the order is in their file, even though they didn't file it.
Exactly. See what I'm saying? So it's like a blanket thing for everybody.
So the only one going to get screwed over is those who took the plea deal. Pretty
much, because they locked in to them consequences. But yeah, everybody that's stuck it out, like right now, these 6 people, these 6 men, and then the 12 that's still locked up, it's over with, man. It's a done dot. I wish the state would just save face and drop it, but it's a pride issue. And then there'll have to be a lot of, answering, like what happened, why, you know what I'm saying? That I don't think that the other side will want to do. I think you pretty much killed your interview yesterday with the state side.
AJ. I'm done.
I mean, the way that she looked at you, or the way, you know what I'm saying, she said she looked at you, it's over with.
No, she said, that's the sound she made.
But I wish she could. I wish people understand. It's just business. You're just a journalist, so
nothing personal. It's nothing personal.
It's not personal.
I don't take nothing. But I still think they're nice women. I do.
They just suck as lawyers, but they're great people.
Oh, I didn't say that. That wasn't my word. That was not my word. Because I said Love would be a great defense attorney. I said that. I mean, because I would hire her to be my defense, because I know she would not give up on my case. So I give her kudos and fighting and fighting and fighting. I might not like it, but she fights.
She does. It's just the way that not just her, but just the state, like what you just read, how those men, how they lied on him, said he had a gun and all this stuff just to keep him in jail. And then it took his lawyers to prove that just to get him a bond. So imagine all the other defendants, they didn't lie to keep them in jail.
Y'all say thank you to me, because y'all would never known about that, because there was a plea. And
yeah, definitely. We appreciate that. And that's one of those small tidbits that people don't know. The only person that got a bond out of YSL had to fight for it, and they lied on him to get it. And he the one that got the body. Charged with the body. So
got charged, not he did.
Yeah, that's why I say charged. Allegedly, he's charged with it, but he's the one that gets the bond. You got other defendants who don't have felonies, who probably ain't been arrested.
But this is the first time he's never had a felony.
Hey. So if that applies to him, that should be a blanket for all of them. I mean, those conditions are crazy, to have to, sit at home, curfew, can't drink, can't be around drink. That's crazy. But
he can be around drink. He can't be around a gun.
No, I thought I could have swore it.
He can't be around somebody who's doing that craziness.
Right. It said he can't consume or be around it.
Yeah.
So.
But I mean, if somebody else is drunk, as long as they're not actually smoking weed and drinking around it. But if a person come in front of him, they drunk. That's
right. Yeah. Somebody in the chat asked, how does the state get away with these blatant lies they tell to these judges to keep these men in jail. And then when it comes out that they lied, why are there no consequences?
It should be some consequences. But they got to go through a whole bunch of stuff.
Right. So, like you said, basically the people who took the pleas are the ones that just, they wanted to get out of jail so fast, so bad. But had they not, this could have been over with. It could have been dismissed, could have been dropped eventually. 2 years removed.
Mike said, there go my buddy. Mike said because of belief. Belief. That's why. He answered your question.
Gotcha. I see it.
They believed it.
Them and I want to know what the residents of Fulton County are going to do to fix this mess. I mean, the only thing you can do is, voice your opinion, which is to go to the polls, but you have to do that in masses. But I definitely think that it's about to come to the head. Still has been drafting all these strong worded motions, very specific. It leaves no room for error, and the state got to answer to it now. They can't, continue to have that blanket of just love going up there, talking her way, to her way.
Mike, you got so much to say in the chat. Come on up here and say something. Mike, come on. You scared of me? Come on up here. Mike Ramsey. The man that tells me it's okay for a police officer to lie. Come on up.
Mike said it's hard to prove they didn't know what they were lying about. Not true. If you blatantly lie, tell somebody, hey, there's a gun and cell phone, and then there's no evidence of said gun and cell phone, that proves that you blatantly lied.
I can't wait to see the jurors come back.
I want to see their faces. I mean, you're going to see their faces, so...
I can't wait till they come back, y'all.
It's their demeanor that's gonna tell it, Sylvia. If they still gonna be, nonchalant.
Hold on, let me say thank you for the membership. Thank you for the membership, Mr. Prince. Say that name, please, Jones. Mr. Jones. Is it Prentice?
Mr. Jones, that's his name.
You acting like me. You can't read like me.
I mean, that's his name, so however you want to say
read like me. Mikey, Mike is in the house. Hey, Mike.
What's up, y'all?
What's up?
Hello, Michael.
How y'all doing?
I'm good. Mr. Scholar of the Police Lying Felices, how are you?
I'm all right. Just trying to get myself up to mow the grass right now.
Hey, do you do grass all the way over here? Cause man, I need a lawnmower or something. I need somebody because I can't cut grass because I'm allergic to that stuff. So, and I'm like, Lord, I need somebody to cut my grass.
I worked at a golf course for about 4 years, so I do love mowing grass. But today the sun ain't out; it's cloudy. I just feel like.
You see how you're not answering my question, y'all?
Well, I don't know. I don't.
Just joking.
I don't live out there.
I'm just messing with you. So, Mike, what is your thoughts?
Yeah, it's a mess. I'm not getting real excited. I have a feeling that she's gonna keep on with the case, but she threw some hints, kind of some hints like if this case goes on, and but at the same time, just the way she was doing the scheduling just made it just seem like, hey, we're gonna go with this. So I have a feeling that you're going to be in court every day for the next 6 months.
I respectfully disagree with that, Mike.
I just,
Mike, but hold on, Mike. Here's the reason why I'm going to disagree with you on that, right?
okay.
Because remember, she hasn't read all the motions that's being Gary be piled on her. She has not
That's
read it.
true.
She don't know what the facts are. She don't know what if there is any constitution violation. She doesn't know any of that stuff. Now, but remember what she said. If there's some constitutional violations on this table here,
She would hear it. Yes.
I'm going to stick with what the law says. So that's me saying in my own word. She's going to stick with what the law is. So she's giving you an overview of what she's coming here to do. She came here to be the referee of this case, and she's planning on being the referee. Now, if other things happen, that's where that if come that you talked about. If
Yeah.
other things come about, I'm going to rule based on what the law says, and that's why I disagree with you in that, because she don't have
I hope so. I really, really hope this case ends because it is a waste of money. It is a waste of people's time. Yeah, all the evidence so far has just been
Hearsay.
it's a very weak case, and it's just
Mike, and also, did you hear what she said about? Remember when that lady got up and was talking about the surveillance thing, that that some evidence thing, right? And she said before any witnesses come up, she's gonna go through it, and if it means that we push the jurors back and not come in on the 5th, we're gonna go through it before anybody comes up. So that means she's going to take the time to review everything to make sure
yeah.
she makes the right decision and not mess up anything. That's where I think she's going to be very thorough. She's going to be detailed, and whatever decision is made is going to be the right decision based on the law.
Oh, you could see when she said that she wanted the state to give them a list of all the witnesses, what they're going to say. She was talking about all the, I guess, the evidence. I don't know if she meant just videos and audio or.
She said everything. She said everything. And then give it to her so she'll have time to review this stuff.
Yeah, and you could see Love look at Hilton with kind of a side eye, like, because Glanville has just been letting them, like Glanville said, like, hey, if here's my file. If I can beat you with my file, I have no problem showing you. But they've been real funny about sharing the exact evidence, so they've been just piling a bunch of crap on top of what they're really going to use. But this judge was like, no, if you're not going to use it, I don't want it. And it looked like they had an issue with that. Love kind of gave a little side eye when she said that. And I don't think they're going to like that. I don't think they're going to like that at all.
I mean, because I believe the last guy was omitting a lot of evidence, and I use quotation marks, that shouldn't have even been omitted if it was another person. So now that side eye that you saw when the judge, when Whitaker told her, like, hey, I'm going to go through everything, and if it's not admissible, it's not going to be admissible, and I'm going to use, like Sylvia said, that rule to where you're not going to keep repeating the same evidence or the same thing. So, cumulative evidence. Yeah. So, and that was big. That's all she was doing. We would sit here and listen to days and days of the same thing. The same 5 cops coming over talking about the same incident. Like, why? Yeah. We don't need 5 points of views from the same thing. Get to the substance and let's keep it to that.
Yes.
It seems like the state's strategy was to confuse the jury and throw in crimes as if these men haven't been to jail for them already, or even if they talking about the 6 defendants. I mean, because a lot of the stuff they was talking about was guys that's not even in the freaking courtroom.
Yeah. I've watched some mob Ricos before. And usually with a Rico trial, they have a lot more than just these kind of petty crimes. They have like ledgers with money, millions of dollars being frauded or
Right.
you know, they haven't really. It's almost like, because you know it's not illegal to be in a gang, but they're trying to say that the influence that they're gaining in furtherance of the gang is just repping the gang. And uh like that one video where he was, I don't remember the defendant's name. It was the game video where they were in the car, and
Yeah.
they were trying to admit that, and I think it was Hilton or Love, I can't remember, but they were like, well, how is this in furtherance of the gang? And they were just like, oh, well, if if you backstab or try to mess with us, YSL, we're gonna hit you, and that is in furtherance of the gang to show power and influence, and it's just like it, it's a real stretch. You know what I mean? Like a lot of this stuff is a real. They're just throwing stuff at the wall to see what sticks, and it.
But Mike,
Yeah.
you know, Mike, you know what I want to say too is even if they go all the way down to 6 months that you talk about, right?
Yeah.
Even if they go all the way to the point where the jurors have to make a decision, there's no possible way you will get a verdict
Oh
without
no.
doubt.
No. Yep. I don't see it at all.
Yeah.
I would almost.
You got a super
rather.
chat, Sylvia.
I would almost rather them go to jury verdict, because because it's just blatantly going to be not guilty, and there's no way that the state can go back on a jury verdict. Like, I mean, they could appeal it, but it's harder to, once it goes to appeal, it's a lot harder than if it was a mistrial. And then you're going to have to argue whether it's with or without prejudice, and the jury verdict is more set in stone than a mistrial would be.
Because it makes you not give them another chance to come back at it.
Yeah, like what Weinstein. I think Weinstein said that he doesn't want them to get another hack at it. You know, I mean, because knowing Georgia, Fonnie Willis in her office, they would definitely learn from their mistakes and come back.
That's why I would rather for it to go to the 6 months, like you said, all the way to the end and get a not guilty verdict. That's the way I would want it.
Yeah. That's because any defendant or anybody will tell you that. Yeah, I mean, the appeals process is there for a reason, but it's really hard to win an appeal, a state or
not for Steele.
Steele is 45% and win.
Well, yeah, I mean, there are lawyers that are really good at.
But come on, Mike, from the other stuff that's been happening, this is an automatic win appeal.
Oh yeah, if it went to appeal, they would automatically overturn it because of the. Sorry, I'm trying not to cuss.
Right.
The shenanigans that are going on, it would definitely be an automatic reversal.
But in my opinion, I think we've seen the last of Woody on the stand.
Y'all both talking at the same time. I can't understand neither one of y'all.
I'm sorry.
My bad.
Am I delayed?
No, I hear you. You probably got your YouTube on in the background. So that's probably why you hear delayed.
No, I got the YouTube off, but the audio is coming through my speakerphone on my phone. I don't have a.
Someone in the chat mentioned the lyrics. I think we so far removed from the lyrics in this case, like it don't even matter about the rap no more.
Yeah.
Yeah,
Let me go ahead. let me read Danny's question here. It says, Miss Sylvia, do you know how much money Nutt's family was promised if found guilty? I really don't know. I don't know on that one. Thank you, Danny, for that question. Go ahead, Mike. What were you saying?
Yeah, the lyric, they haven't, I mean, yeah, they've used some, but yeah, like AJ said, we're so far removed from the lyrics now that I think they kind of abandoned that that cause with the lyrics.
To Tori's question, she was mentioning how the deputies were telling, but last night, Weinstein was on one of y'all lives, one of y'all channels, and he broke it down. It's basically, it adds more work for everybody with all those wardrobes there. Because like you said, Sylvia, the family brings it into the lawyers gotta give it to their clients, and then the bailiffs and the deputies gotta store it. It just adds to it, to their workload.
And
So
I
I can understand them
I'm
not
gonna use
having.
Mike because Mike much stuff is making noise while you're talking. Go ahead, AJ.
No, I was just mentioning, how that the wardrobe change, it adds to the workload of the court. So that's why she mentioned it. Weinstein broke it down on the channel last night, and it makes sense. Less workload for everybody with their wardrobes.
Okay, Mike, go ahead if you was gonna say something. But let me tell you, I saw poor Mariah struggling carrying all those heavy, big bags. She had to get somebody to help her to get it outside. So it helps them too, because she was struggling, y'all, with all those clothes.
I mean, she the one got all that spider gear.
It was so I mean, her little self trying to carry all those bags.
But you gotta remember the burden that's on these men, because they getting hauled off, shackled up every single day, coming back and forth, to this courtroom, and they're there literally all day. They get there well before anybody else gets there.
Yeah, Jeffrey has to get up at 4 in the morning.
You understand? So they getting at the courtroom at 5 a.m. and not leaving till at least 5 p.m. and then go back and not be comfortable in their cells just to get. It's a heavy burden that these men have endured waiting for their freedom.
Yeah, that's and that was another thing that when y'all were talking about the plea deals, or I was seeing in chat about people were probably punching the air because of they see this going on, but they took a plea deal, and it's like, if they would have just been patient and just let the process work, they wouldn't be in that situation.
Who be patient?
Who's all taking plea deals? Let's see. It was
Wait a minute. I mean, I get you saying now, but you got to understand those pleas were just, some people can't afford to sit in jail.
Yeah, I understand.
I don't think nobody could afford to be put in jail.
I mean, nobody can, but Jeff definitely can versus, the other guys.
Yeah. I mean, I understand it's.
And then remember how was it DK who shot half a head? He went and did his time for it, went to prison, got out just so Love can hit him with a Rico to throw him in jail for the same thing that he just got out of prison for, just so he can take a plea deal to get out of jail again. Come on, man.
Yeah, that was.
That's playing dirty.
Yeah, this whole thing is crazy to me.
So those 9 individuals that took the plea deal is, like he's saying, punching the air right now because
I mean, I guess hindsight is 2020, so.
Yeah.
I mean, yeah, but those plea deals, what they consist of, if you can remember off top, you ain't gotta look it up.
I got a couple of them that I could do it. I could do it.
That was like 10 years probation, right? Some stupid number like that.
Yeah.
That's
Guys,
crazy.
okay. I have message from Ghost. Ghost said, please watch out for the excessive emoji, aka spam, that will cause YouTube bots to delete the live stream. So why, Ghost? Who?
I can't see the chat, so I don't know what he's talking about.
I don't see anybody doing too much emojis.
All right, well,
So people in the chat saying they got 15 years, 10 years probation. Like, that's absurd, man.
yeah, that's crazy. I would have.
Suspended sentence, but they so bad. That's why I knew the case was weak when they gave out plea deals for probation and they said that YSL is this big bad Atlanta gang and all the crime gonna stop. So why are you giving probation if they so bad?
Yeah, a lot of this I think is political as well.
I mean, that's the undertone of this case is the political aspect of it, but those 6 defendants don't care about politics.
Well, yeah, but you know, Fannie Willis, that's probably all that's on her mind, really.
I mean, it has to start from the top.
Yeah, it runs downhill.
Yeah.
All right, Sylvia.
Mike, it's great having you up here. Don't be a stranger, okay?
Okay.
Green said, how do you get probation for a crime you already served? It's because she recharged him with Rico. That's, to me, that's the way around double jeopardy. She included his previous crime in the Rico, so she locked him up for the Rico, which forced him to take a plea deal to get back out of jail for the same thing that he had already did time for. They haven't stopped. Atlanta crime hasn't changed any bit since YSL has been incarcerated, and that goes for all the other Ricos before it.
Okay. Mods, we're gonna have a meeting very soon, like tonight, because I need to discuss some stuff with my mods.
But yeah, I think once I saw Woody start doing interviews, and now with the motions that still is filed, and how on point they are, I don't see Woody being a up on the stand anymore, which throws a wrench in the state's case because they're gonna have to pivot and do it fast. They're not gonna have the excess of time that the other guy was giving them.
Yeah.
But your coverage of this case, Sylvia, has been the best, and thanks.
AJ, I wanted people to really experience what I was experienced, that I am experienced inside the courtroom. I know it's so hard for me to basically explain some of the things, but I wanted to do like the human side. That's why I was telling Weinstein as well as Chart about it, because what I see is not what everyone that's watching this case see. You get what I mean? They don't see his mom in the wheelchair sitting there day after day having to go through this, and they don't see the Nutch family, and I mean it's just a lot of factors that come behind this.
Right. You got the families that are affected. I remember that a meme. You would probably tell me who was he motioning to. He had on the yellow spider jacket and he was tell somebody not to cry.
Hold on. Ghost, I'm not too sure why you putting things like this here about Ghost. I don't know who you are, but This is kind of strange. You putting this kind of message on here. It says here, YouTube has defined excessive emoji as spam based on the old spam bot behavior. Just ahead up, Kayla was having difficulty with YouTube removing. Okay, why are you? Okay, I've been on YouTube over 5 years, Ghost.
I mean, we can rectify that, Sylvia. Just say the word. Say do it.
No, I mean, this it's kind of weird. This person's coming in and all of this posting stuff. It's kind of weird. And Kayla's stuff disappeared now. All of a sudden, they're coming over here. Please don't try to do that over here. I've had my channel for years, and if something goes on with my channel, I'm expecting that somebody's behind this.
Y'all asked why I keep calling him the other guy. It's because, I mean, he was never a judge in my eyes. He was always biased, so I called him Euro by his name, respectfully. And then when he started cheating and got removed, he became the other guy. So that's why he's the other guy.
This person is, this is weird. This person coming in here like this. This is weird.
Sylvia, all you got to do is say do it, and it's over with. And you won't ever see Ghost again. Oh, somebody already did.
Mm-hmm. It's kind of weird. It's some weird movement. I don't understand what the purpose of you coming in here with all this stuff. It's not. I don't like that. I really don't. Don't do that. I've been a content creator for over 5 years.
People saying that that's a bot, Sylvia. So I don't know. But yeah, like you saying, you see the family coming in. You see them, being attentive every day and supporting those people.
You said they removed ghosts. Why am I still seeing ghost messages? Ghost must work for YouTube.
Carvel said ghosts are mod in all the channels on YouTube.
That's kind of weird.
I mean,
something's not right. Why didn't I help who? How's he trying to help putting this up? Yeah, I've been a content creator for many years. Seriously. Y'all were doing some weird stuff, man.
I don't know, Sylvia. You got a lot of attention now. A lot of people listen to your or tune in, from the bushes, as they say, to see what what you got going on, to see what you're saying, because you are the only eyes that are actually in the courtroom that then come back to these YouTube streets. So you can report on things that other bloggers or other journalists can't, because they aren't there. They can't gauge the temperature of the room. How you said it was feeling a little different. It felt weird. The cloud was lifted. The defense was smiling. Max changed seats. Like everything was falling into place. They can't see that through their whatever screen they watch it on.
Yeah.
But I was asking you, who was he gesturing to, if you can say, when Thug told somebody stop crying? You remember that?
You're gonna ask me something from long time ago. You should ask me the day it happened.
I don't remember. Roxanne
said, the guys that took plea deal early on, what did their plea deal consist? It was some of them was a lot of years. A lot of years.
They said it was his mother. Okay, cool.
I didn't know it was his mother. They wasn't even there.
Oh.
They say it was his mother. Oh, Lord.
Somebody asked, can you copyright and trademark your work, Sylvia?
That may be move you want to look into. I see a lot of people feeling to credit you for your work. Sylvia, but he is a real active person in the community. He's gonna be spreading the ish to all the other channel too. Gotta play it smart, delete him. What are you talking about? Y'all, stop it with this. Oh my God. Y'all too concerned about stuff that's not. We're supposed to be focusing on this case here. That's what we're supposed to be focusing on. We're supposed to be focusing on what teaching, learning. We don't care about this other stuff here. Y'all stop it. Y'all, it's a distraction. Y'all getting distracted.
Nick says, I've been following this case. I've watched everything about this case, and thank you for all that you give us, by the way.
Thank you. Thank you. Let's focus, y'all. We came in here to talk about like the paperwork that I just showed you guys with Miles Farley. It's the first time you guys actually seen what his bond thing was, what his attorney wrote to basically get him the bond. That's what we need to be focusing on. Let's not focusing on what these people doing. And
will the motions be televised next week?
The motion, yes. Everything will be televised.
Okay.
Everything will still be on televised, yes.
Green wants to know when is the meetup?
I have to talk to Cadillac about that.
Cadillac Nick, I remember him saying on his channel he's going to be in the country on the second week of August.
Yeah, he said that he's going to be in there.
So we get all the YSL correspondence in one room. That's crazy.
That's going to be great.
That's good. Great.
Yeah.
Somebody asked if Woody still is a sworn witness currently, will his internet run damage the case?
I really don't know. I really don't know.
In my opinion, Woody is done being on the stand.
You think so?
Yeah, man. With given Steele's latest motion and given the way Whitaker presented herself the first day, you can't go against the law. If the ex parte, if Weinstein filed recusal, and then the ex parte happened, and then you have to go to the date that the recusal was first filed, then that strikes everything Woody.
Thank you, Miss New Orleans, for the super chat. Thank you. You said Love will lose her license. That's what Rick said. Oh, that's a question. Oh, that's a question. Okay. I'm not too sure. About that. There would have to be a hearing and all that kind of stuff. I'm not too sure.
Right. Woody hasn't been saying anything, detrimental to the case. He's been mindful of his words.
Okay. Thank you so much for the Cash App. I got a Cash App from My Name Is. Thank you. Thank you. My name is.
Astrology asks, do you think you'll allow... Never mind. They recanted their question. We just went through that, Kimberly, where Thug is actually charged with. He got the Rico and some gun and possession charges, drug possession charges. What it was, like 6 Rico, and then like 5 other charges of possession and of gun charge. But once this Rico is gone, that everything else is in the bag. Of course, Cam. Gotcha.
He said the gun charge was probably be charged federally. What gun charges? You talking about not if it was messy.
You see that? Somebody wants to know what qualifies as prosecutorial misconduct.
Doing stuff that's sneaky.
Right.
Planting evidence, holding evidence, stuff like that.
Speaking of holding evidence, so if it turns out that the state actually has a report that they've been burying somewhere because a cop confirmed he was at the hospital and the witness said that he was in the hospital. If they find that report, isn't that grounds to mistrial right there just on that alone?
Not too sure.
Not sure.
Mm-mm. And I ain't gonna tell you something I don't know nothing about. I ain't gonna lie to you.
Right.
Guys, you're asking so many wonderful questions, but I don't have a clue. I don't have a clue. I'm serious. I don't have a clue. If somebody says, which gun charge in the car with Gunner and when they raided the house was his 2X? No. I guess it might have been incorporated in because they generalize it, but then when you read the actual act, we can go into the act and read it if y'all want to do that. And we can go, play detective and go into the act and see exactly what it says about that particular act.
I can't see it, astrology. That's what happened in the Baldwin case, lady. I mean, yeah, I figured that much. So, keep your fingers crossed.
Has any lawyer stated they will be asking bond next week? I know Weinstein said it.
Somebody said when this trial is over, can you reveal the mode of the ex parte?
Thank you, Jimmy, for the Jimmy Figas for the Cash App. Thank you.
Is Miss D. Williams coming back, or is she?
She's not feeling well.
Oh, she was sick. Okay.
Look at my message. You see it?
Yeah.
She's not. The other lady is the attorney on record now too. So she's not just sitting in anymore. You know how she used to come in and just sit in and be out like when Miss D. Williams has something to do. She's just not gonna be sitting in there anymore like that. She's part of the case.
Got you.
So they can do switcheroo whenever one is not around. You know what I mean?
Yep, I do.
And the other thing too, hold on a second. I gotta see if it's okay to mention this. So just give me a moment because I want to mention something, but I need the approval to mention this. Okay.
Cool beans. We're standing by.
Talk to the people while I go and ask for permission. All right.
All right. I think the mode is Caucasian prosecutor who was not in the meeting. All right, lady. Do you guys think the jury has consumed any of this? Like realistically? I think they have. At some point, they have had to. Yes, Emmanuel. I think Whitaker is definitely going to handle. That's why she wanted everything. She wants everything to be streamlined, so she's looking at the motions probably as we speak, and is going to rule on everything appropriately. Well, hey, Judge Whitaker, if you're here, Kimberly says. Said they're probably in the chat now, Green. Probably so, man. Because they're real people. You know, can't not pick up your phone, man. Can't not watch the local news. So there's no way around it. And being here in Atlanta, y'all, at first they wasn't covering this case. This case was not on the local news at all because for what? But when all the shenanigans started happening, then the news start picking it back up. Oh yeah, Shan. That thing they've been new too, even before they, when they was in and out of all them comfort breaks. That's a good question, T Mac. Can the state so what we gonna do? Just go back and forth with judges or who you like, who they like? AJ, would you please share what has taken place? I just signed in. Well, we went over Steele's motions, which was basically to strike Woody's testimony, which was to remove Hilton and Love. We went over the only YSL member that got a bond and how he got a bond. Initially, the state was lying on him, saying he had guns and cell phones in jail. That was in order to keep him there. Then his lawyer proved that he didn't, so that's how he got a bond. Then we went over Thug's actual charges, which is just the Rico and like 5 or 6 other possession and drug possession and the gun possession charge. So that's the gist of the lie. But she has life outside of work. She doesn't seem like she wants to spend unnecessary hours. Oh, definitely. Nobody wants to spend unnecessary hours at work, Coco. That's why she was like, dang, I was supposed to go to the judge conference, but now I'm stuck here with y'all basically type. You know what I'm saying? So yeah, she definitely want to get this over with. And the way that she was talking, she know it's been a bunch of shenanigans and she's not going for it. I am Brandy. Thank you, man. I try. I want to know who she talking to. Oh, lady.
You are
Blessings
so
from Africa.
nosy. You are so nosy. He told me he wants to know who she talking to. He wants to know who she talking to. AJ's so funny. I can't divulge the information yet until I get approval. So I will not talk about it.
Cool, man. Well, apparently so, Pam. I mean, when I'm just in the chat, just chilling, man. Even when Pastor up here, I'll be asking to get up here.
Yeah, AJ been around for a while, and I thank him for sticking with me. You read Sylvia's lip, whatever. Mike is such a troublemaker.
AJ, so
Sylvia, I read Sylvia. Sylvia.
Kimberly said so. AJ, when
Okay,
Woody
hold
first
on. The person calling me back.
okay, so when Woody first took the stand and pled the fifth, the other guy said that he doesn't believe the state knew he would plead the fifth. Now we know, could the defense use that? I believe so because we know the other guy knew. And the Melnick, Woody's lawyer, the white dude, the first lawyer, told them that he would plead the fifth. So they knew beforehand, but they just wanted him up there. Again, it was not about what Woody was saying or what questions he would or wouldn't answer, because whether he answered them or not, loved and wanted to play those old interrogation tapes thinking they would help. So that's all that was about. Because if Woody had a pled the fifth, which he did, and he went to jail and he was ready to stay in jail, and then they bullied him into saying you're gonna be in jail not for 2 years but for indefinitely, they made him get up there. So they was just desperate and needed him up there to play those weak tapes, to me, in my opinion. Right. Had they let him plead the fifth, none of this would have happened. But they wouldn't have had a case, Carvel, because the whole case was hinging on Woody's old footage of him, quote unquote, snitching. And to me, if you watch the footage like we all did, the police wouldn't even believe in him. So why 10 years later, you now believe him? Oh, I don't know, Renadad. What the hell? I don't know if they job on the line. I mean, their reputation is definitely tarnished. Right. Who can remember 10 years ago, man? You say don't call him up green. I talked them up, man. Right. And if you barely remember what happened last week, imagine how the jury would feel being tasked with remembering what happened January, February, March, December. You know what I'm saying? Like, come on, man. They ain't got enough notes in the world for that. Especially with all the nonsense witnesses they've been had to sit through. There you go, Tim. The state knew according to the transcript, but the state just wanted those tapes in. Shell, I have a question I can't get out my head. Just speak it. But this has been a S show from the jump. I wish they would fix those raggedy mics in the courtroom. I don't know if they really raggedy, Coco, or they just don't be talking in them like that. Because when they be standing up, I can't hear them until they, get into the mic. Nope. This new judge will not be allowing that. And you can tell she was talking directly to the state. Astrology YouTube is removing the question. Well, type it one word at a time or something. I don't know. It's too long to type. Well, you should come up and speak your question then, Shell or Shelly. Mike's are red. I feel bad for middle chair guy, y'all. Like, I don't remember his name, but he's constantly been in the middle of Love and Hilton's back and forth. And I'm just like, Jesus, God, just back up, man. Let them talk. Do y'all think the state will continue to block the camera or will use the podium for here on out? I don't know why Love them was playing those camera games, man. Because it seemed like every time Brownie got up there, he stood at that same exact, like he had an X on the floor or something. I don't know why they was playing those camera. I think they was just being spiteful to Sylvia, probably. But I don't know, man. Yeah, middle chair guy. Oh, his name is Atkins. Well, middle chair guy. Right, Nick. But unfortunately, a lot of guys have already taken pleas, and like we said earlier, they probably kicking themselves right now. But a lot of people can't afford to sit in jail, man. That's all the plea bargain is. It don't mean you told on anything. It just means I want to get out of jail. I don't know, Raven, how she got on the case if her division is DV and stuff. Maybe, she was selected by Love. Maybe Love handpicked her. Because she's a lot younger than Love. I know I ain't going to say up and coming lawyer, but she has a lot less experience than Love has. Oh, yeah, Rent. The jury has forgotten everything other than what they've been consuming, not consuming. My question is above. Astrology, I don't see. Okay, do you think the other guy allowed this to happen because he knew it would help the defense? No. I think the other guy was blatantly trying to cheat his way, their way into a conviction. He went on the record and said he believed the state had already proven conspiracy. How is that, mister? You're supposed to be impartial. But all his actions was very partial. So no, he didn't intentionally do that astrology, and not from his actions. I see what you're saying, Nick. The way the pleas were written, but it's just like if you watched it, the judge was asking them basically, "I'm finna let you out of jail, but you got to repeat after me. YSL is this. YSL is that." Again, it's not illegal to be a part of a gang. Do you think the judge, the other guy, is still on purpose? Oh no, I already read that. No, I don't, astrology. I don't think the other guy did this on purpose. I think him and his dog was taking too much stress. I don't know what doo-wop at, man. Maybe the state knows financial. Thank you, Unpopular. Those pleas were very Simon Says. Very. I mean, he basically just had to read the plea agreement out loud, which is what Love made all the rest of the guys do. Remember back when the DK and Bean all them was on stand, when they wasn't answering the questions right, she pulled out those plea deals where you pled to this, you pled to that, as if that, proves anything to the jury. And then the other guy was always wanting the jury to leave it up to the jury. Leave it up to the jury. You know what I'm saying? That's what he kept saying. I was like, nah, don't leave it up to the jury. You can determine this, sir. I have no idea if Love and Woody family member had any type of dealings. So I can't speak to that, doc. T Mac, the other guy, got me hollering. I mean, that's his name, man. I don't like him, so I gotta try to be as respectfully as I can be on Sylvia's platform. Exactly, Tori. A lot of things the other guy let in, the jury wasn't supposed to even see. That's why all the objections was had. Over everything was allowed over objection. Come on, bro. Yeah, man. I'm doing the thanks screen, man. I'm on the clock and shit and stuff. You think so, Nick? I don't know if it was unconstitutional, but it definitely wasn't, you know what I'm saying, to me wasn't right. Like you are the end all be all. And I think a lot of some of the YSL Avengers was telling him that, no, your honorable court or whatever they was, saying to him. And he was like Shar said yesterday, the last guy kept pushing everything back. We'll get to it then. We'll get to it when we get to it. Instead of trying to handle it now type. Oh, thanks, Jason. You won my heart. Cam, I think the strategy of Hilton and Love for them to use the witness whom don't remember. They didn't know they couldn't remember, so they could use the videos. Yeah, that's all she wanted to get to was those Rico interrogation videos with him just rambling for 8 hours.
I'm back. I'm back. Hey guys, I have some intel.
Uh-oh, y'all, we got some tea.
I got some intel. Hey Michael, welcome back. Welcome back. All right. Now y'all know Little Rod, right?
Yes.
You know he has the case that he was convicted of, right?
Correct.
The judge that convicted him was Judge Ingram.
Okay. The one that just removed herself.
Just remove herself. That is another reason for the removal too, conflict of interest.
I mean, this case is so broad that it seems like some of the defendants is hard not to be touched. You know what I'm saying?
Mm-hmm. And so his case, his new trial was supposed to start with Judge Ingram on August 3rd, but now it's going to be like pushed because he's still in this case here.
So he's on an appeal. He's already been to trial, convicted, and now he's appealing.
There's an order made for appeals for the overturn of the and Judge Ingram is the judge that's back on it. And guess what? In 2015, he was only 7 years old. He does not know Young Thug.
That's what I've been telling in the chat. Like Lil Rod, they just throw his body in there because it's strengthened the Rico. He don't know nobody about nothing. I think the only reason they threw it in there.
He's only got charged as a Rico. There's only charges of Rico in that case. And
thank you. And I think the only reason they threw the body in there because of where it happened at, right?
Yeah.
So come on, man.
Y'all remember? Supposedly they claim that Young Thug told him to do it or some mess like that, but he doesn't know Young Thug at all.
Right. So how you just gonna throw people into a Rico who don't know nothing about nothing? They sitting here looking at him like, who that dude?
Yeah, his case got overturned, and there's a new trial supposed to start, but they have postponed the new trial date. So
that's crazy. But yeah, I was always asked, like, come on, bro, like, because y'all remember back early when the state was all on Cleveland Avenue. Everything was Cleveland Avenue. Everything was in the vicinity of Cleveland Avenue. It's like, you just gonna get all the pickpockets that happen on Cleveland Avenue? Like, come on, bro.
They said he's been in and out of jail since he was 14. He's been...
So Nick saying he was a runaway child, but I mean, still, he ain't got nothing to do with none of these men. That's just throwing a random act into a Rico to give it some strength. Because without his body, what you got? You got a bunch of nickel bags and random carjackings that didn't even happen on Cleveland, but ended up on Cleveland. Like, come on, man. It's like, it's crazy. Imagine him sitting there and they talking about 2015 and he can't even remember that because he was a
7 years old when they started for this case fit to 2015, 2013, and all. Oh, he was what, 5?
Oh, and I laughed out loud when Judge Whitaker said, and we're not going to be looking at old IG posts. I was like, yeah, we don't want to see that. That you conveniently edit out the timestamp of. I wonder too what Tick and Bean is up to. Hopefully living their life far away from anything Fulton County.
Can they move out of state? Those that have like can they move out of the state?
If you're not on anybody's paperwork, then you're free to do whatever you want to do. But I doubt they have.
No, I'm saying, can they like just send the money in or go down to another state?
It'll have to be approved because I've been on paperwork to where I've had to ask permission to go on vacation. Yeah, it'll have to be approved.
I mean, can they move? Like, say they decide to go to another country.
Yeah,
Would you think they'll stop them from going to another country?
I don't see why they would, but they probably would, just being spiteful. But
then they'll be out of their hair. You understand what I'm saying? They don't have to be responsible for.
You're right.
She said Miss Love gave Miss Sylvia a pair of eyes on that media talk part. No, that was not me. That was not me. That was not me. That was Turtleneck. That was not me. That was not me.
Somebody asked, did Judge Whitaker give Woody bond?
Woody?
Yeah. Gave Woody bail in the previous case.
Oh, I don't know. I don't know. Well, Kayla said she had Judge Whitaker, but I don't know if it was for Woody. I don't know. For Mr. Kenneth Copeland. I'm sorry. I don't want to call him Woody.
I wonder if they have a medical necessity. What? Right, lady. For her not to be following, she sure knew a lot what was going on. But hey,
AJ, don't listen. AJ, don't listen.
Okay.
You don't listen, do you?
You're right. I'm hard-headed. I'm sorry.
But remember, she has deputies that's been on the case. She had a deputy that's been on the case. So you know he probably gave her 411, just like they told about the clothes and all that stuff. Come on. You know that? AJ.
Yes.
You're not even listening to me now.
I am.
You're not even listening to me.
I am.
No, you're not.
I am attentive. I am here. You hearing? Carvel says he doesn't like his nickname. Kenneth Copeland is his name.
That's what I call. I call him Kenneth. That's anytime I talk to him, I say Kenneth. Because I always say the other name wrong anyway.
Right.
But the funny thing, he don't correct me when I said it that time, but I try not to say it.
Green wants to. Never mind.
I
sound like Pastor.
You. I'm about to go now.
Ain't that Pastor right there, Mike Williams?
No, that's not Pastor. Pastor's not Michael. His name is Michael Johnson.
Oh.
Not William. I gotta go.
All right.
All right, guys. You guys have an awesome day. I have stuff to do around this household. I can't spend the whole day up in here. I got to take care of home, guys. But I just wanted to come and give you guys some tidbit of education. All right.
Do I have permission to drop a link, Sylvia?
Absolutely. See, that's how we do this. What link you trying to drop?
For my channel.
Okay.
I think.
Let's not make it a habit, people.
Definitely not. One and done.
One and done. But of course, AJ, because he's always showing up here. I'm talking about other people. I wasn't talking about you. You know how folks come in here trying to get their channels up and they want to. But AJ's been very, very instrumental in coming up here and helping a sister out. Thank you, Sylvia, for the Cash App. I appreciate you. Oh, really? Thank you so much.
We still having that meeting they asking?
Yeah, we're having a mods meeting. We're having a mods meeting. And is it a way for me to do a mod only live? Is there a way for me to do a mod only live?
No clue.
Let me see if I can set it up. Hold on, y'all. Let me see if I could do a mod only live. Hold on. Let's see. I know we can do a members only, but a mod only. But mods should be able to come into the meeting on members only. I'll just put it at a high tier and nobody else could come in. I'll do it that $500 tier. Only mods be able to get in. Huh? You think, AJ?
I mean, I'm new to this, so I guess that's how it's gonna work.
No, I'm just trying to see. She said do it soon. No, I'm trying to see because a lot of mods, I'm trying to do it. If I do a tier that's 500, because nobody's ever at the $500 tier, will the mod be able to get into that?
We're gonna find out together because I don't know either, Sylvia.
Okay, I'll do a private link. Okay, I'll do a
private link with the mods. Okay.
But see, the thing is, it's hard for me because some people got weird names here. I don't know if they're mod. You get what I mean? If I do a YouTube mod thing and make it only mods only, put a higher tier, there should be a way to add mod only. Okay, so yeah, Unpopular said I should be able to do that. Hold on a second. See, the problem with me doing the meetup, right? I don't know people's real name when they come in there. It might be totally different. Don't put your email in there, Keon, because somebody's going to come and try to email you. You don't want folks getting your email. These people weird around here. You won't know who the mods are if you do a Zoom. You know what I'm saying? You won't know who the mods are. If I put the link in here, I won't know who mods are. You know what I'm saying? Okay, let me see something. Let me do a test run here. Don't get off, y'all. Hold on a second. I'm going to do a test run. Let me see another one. Hold on a second. Let me just do a test run. Hold on a second. Hold on. I'm testing it out, good people. I'm going to end this live. Okay.
All right.
I'm going to end this live, and y'all come on into the other one, and I'll set it up. All right. See you guys later. Mods only meeting coming up. See you later.